Yes, sir. Yes, sir.
So, welcome to trainer CA Pooja Madam. So, today we are entering to the second part of our mains, that is business regulatory law compliances. Okay, welcome, madam.
Thank you, sir. So one question is why uh, Contract Act came into force? The first question is why Contract Act came into force? No answer. Regulate the business. Okay. Proper business understanding between the parties. Ethics. Okay. So two examples I'll give. So in one example, so I called to my friend. Okay, my friend called to me where he told that we'll go for a dinner today evening. So I forgot and I didn't go. Is there any contract? Is there any contract to me? Is I'm liable to him to pay any compensation? No. So I'm running an hotel industry where a customer called me and asked me the certain orders. So I failed to deliver to them, to the customer. Now there is a contract. Yes. If I fail, if I didn't communicate, what would be there? Yes. Legal binding. Yes. Agreement, penalty, bad name, losing the business. Whereas if I forgot or I didn't go to the whatever the call made by my friend, in that case there is no legal binding. Okay. Similar in contract. So we will learn with just 5 case studies where the act can be understood. So first case is Balfour versus Balfour, where wife and husband. It's between the wife and the husband. The wife and husband were on the trip to the England. Okay, in England, wife got ill from Ceylon to uh, England. So husband had some work. So he returned back to the his home country. So since she was ill, he was paying certain sum of money, certain sum of amount to maintain her life or for medical expenses. Okay, say of monthly of uh, 30 pounds. Okay, here after few times, after some time, so there was a misunderstanding and they were going for a separation. So then next, wife filed a case against the husband that he is liable to pay for the maintenance of for the maintenance of her life. So now, is there is the husband is liable to pay her after separation? Yes. No. Yes. How? No. Yes. If yes means why? No means why? Yes. No. Okay. But why? Why husband is liable to pay? Since to maintain her medical expenses, he was paying monthly. It's
It
a
is a
contract.
contract of living.
Yeah, but it's not enforced by the law. There is no agreement or a husband has agreed to pay.
It is
But
a
there
deemed
was no,
agreement. Marriage is a deemed agreement. It's a living together.
but it's not a contract, no, sir. It's not
100%. It's
enforced.
not a contract, but it is a contract.
Yeah. So the court, the decision is the court has dismissed the case since there was no legal intention. So
Hmm.
before separation, there was no legal intention, okay, or obligation to pay to his wife every month. So on this basis, the Contract Act came into force in 1870. So first, there should be an agreement plus enforced by law. So if these two persist, then that is a valid contract, not an agreement. Okay. So another case between Lalman Shukla versus Gauridan. Okay. Lalman Shukla is a servant. Okay. So Gauridan Gauridan is told that his nephew was missing. Okay. He approached his servant that if he get search and get his nephew, so this was the condition. Okay, it is his duty. Okay, to search and get his nephew. Okay. Meanwhile, since he was missing his nephew, the Gauri that has communicated to the public that whoever search and get his nephew, they'll get the monetary consideration. Okay, so reward, say reward of $500. Okay, $500. So this was not known by the servant Lalman Shukla. Okay, so finally he got his nephew. So after knowing that there was a reward announced by the Gauri Dutt, okay, Lalman Shukla filed a case against the Gauri Dutt that he is liable to pay him the $500. So what would be the decision? Should be known at the time of making the contract. Yes. So both the parties should be aware. Yes. Not liable because it's not communicated. Yes. They at the time of entering, there should be a proper communication. Okay. Hence, even it was a duty of Lalman Shukla that to get what to search and get the his nephew. Okay, so in this there should be a proper communication, and the option the court has dismissed the case when you had no knowledge of the offer, when the reward offer was not known. Lalman Shukla is not liable for the reward. Okay, clear? So here, so it's applicable. Now the Contract Act is applicable to all of India. So definition of contract, that is agreement plus enforced by law. Unless it's enforced by law, cannot be an agreement. It will be an agreement and arrangement, not a contract. Okay, promise. So promise. One person makes an offer or accepts, the other person should accept. The time it will be a promise. Okay. In Lalman Shukla case, see, he had promised, Lalman Shukla had promised that he'll search his nephew. But the offer was not communicated to Lalman Shukla. He was not aware of the offer. Okay. Next, every promise and every set of promise forming a consideration for each other. Okay. An agreement, unless it is enforced by law, it will be a contract. Okay, the consideration something in return. Okay, the consideration something in return should be either money or money's worth or kind. Next, all conditions of section 10 legal obligations, like example Balfour versus Balfour, where intention to create legal relationship, it was not there. Okay, so one of the most important element, so essentials of valid contract, where party offers, another party accepting, and contract made by them, either natural person, that is individual, or having a legal existence, either company, partnership, firm. Okay, there should be an intention to create a legal relationship. Okay, social or domestic type of agreements are not enforceable by law. Okay, okay, if you win the case, I'll give certain sum of money. There the consideration is not clear. What is the what certain sum of money? Okay, the possible of performance of agreement. Okay, any impossible agreement cannot be enforced. The essentials of valid contract are: first, offer and acceptance, and free consent. There should be a free consent. Okay, consents ad idem, that is meeting of the minds, and two or more person agree upon something in a same sense. Consent it should be free, and it should not be obtained by any pressure or any what forceful act. Okay, or of because of any influences, mistake, or misrepresentation. So I'm giving a false information to other party. Okay, so on that basis I'm obtaining his consent. Okay, mistake. Okay. So, so any other, like other, either undue influence, fraud, misrepresentation, the contract will be voidable at the option of the aggrieved party. Whereas it's mistakes, it is a void from initial. So, who are the capacity person who can enter into the contract? The person should be major. Any contract what any contract entered with the minor will be void at initial sound minded at the time of contract and otherwise not disqualified. So the consideration should be either something in return, either in cash or kind, and lawful consideration object not expressly declared to be void. Okay, so void means whether illegal agreements. Okay, agreement to restrain the marriage, agreement to stop trading. Okay, so the difference between agreement and contract is offer and acceptance. There was an offer and acceptance, but here it is legal enforcement. Agreement plus legally enforced. Okay, the wider term of it is a wider term includes legal and social agreements. This is a narrow sense, includes only a legal agreements. It should be like the agreement should be printed on the stamp paper and should be registered. May not create a legal relation, but always creates a legal relation. All agreements are not contracts, and all contracts are agreements. Clear? Yes. Transfer of Property Act. So, so the types of contracts. Okay, first is valid contract. So one, all the essential elements. That is, there should be an offer and acceptance and enforced by the law, and there should be a free of consent, and it should not be any influenced for the consent. Okay, so all the essential elements should be covered, and it should be enforced by the law. Okay, that time it forms a valid agreement. Void agreement. So void agreement is which is void from the beginning. Okay, if I make an agreement even knowing that the person is minor, in that time it is void from initial, does not cover any legal effects, and it's not enforceable by law. So one question is, which is Mohini Bibi versus Damodar Damodar Ghosh. Okay. Here, Damodar Ghosh was a minor. Okay. He agreed into contract with Brahmadatt. Okay. Kedarnath is his agent. Okay. He was a money lender. He had received the money. Okay. He has entered into contract for a certain sum of money. Okay. Say it was of 10,000 K. Okay. In this case, Brahmadatt and Kedarnath knew that he is a minor. Instead of that, they enter into a contract and gave the sum of 10K for the certain sum of whatever the land he had. So this arrangement, this contract was known by Damodar Ghosh mother, and she wrote a letter to Brahmadatt that this contract is not valid since the person is minor. Okay, and he is not liable to pay the certain sum of money to you. Okay, then the party Brahmadatt filed the case against Damodar Ghosh. Okay, since it was so it has since the agreement was void, what would be the court decision? It's not valid. Okay, in this case, is minor. What is the court decision? Now, in this case, is Damodar is liable to pay? Court rejects. Yes. Court had rejected the case. Court has rejected the case. So after his expire, Mohiri Bibi, his wife, filed the case against Damodar. Mohiri Bibi filed the case against Damodar under Relief Act. Under Relief Act. The benefit was received. So he need to restrain back. Under Relief Act, the Mohiri Bibi has filed the case against Damodar Ghosh that since the benefit was received from the person, he need to restrain back the benefit, whatever the amount he has received. In this case, what would be the court decision? Agent will pay. No. Pay mother? No. See, first, Brahmadat had filed the case against Damodar Ghosh. So since they were known that the Damodar Ghosh was a minor, since but also they have arranged, like they entered into contract. Damodar Ghosh has to pay. No, the court had intervened, and they told, even after knowing that the person was minor, why did you enter into a contract? Why did you pay him? Okay. So the court dismissed, and Mohiri Bibi was not liable to receive the any compensation. Okay. So in the same case, if I say Damodar hid that he is minor, he pretended to be a major person without knowing uh, Damodar Ghosh is a minor. They have entered into into a contract. Now under Relief Act, will Mohiri Bibi will get the compensation? Yes. No. After major he paid? No. He has hidden the fact. If he has hidden the fact, if he had hidden the fact that he is a minor and he has entered into a contract. In this case, Mohiri Bibi will be receiving the compensation. Clear? So what? My first is should be free. There should not be any force, undue influence, fraud, fraud. I've hide the what? I've hided the what you say that fact fact that he is the main minor, right? The contract is voidable at the option of agreed party, and under Relief Act, whatever the benefits received should be restrained. But I've hide the fact, right? I'm the minor on some purpose. That time his guardian is liable to restrain back the amount received from the minor. So it's types of contract. Next, void contract entered with the minor, voidable, enforced at the option of aggrieved party. Okay. So voidable, where the contract had been entered, but it was void, enforceable at the option of the person who has suffered, whether he want to continue the contract or stop. Okay. Illegal contract where it is forbidden by law, not enforced by law. Unenforceable contract is good in where all the elements are covered but suffer due to technical defects. Okay. So both the parties cannot sue upon each other. So the agreement was, all the agreement pre-consent was there. But since there was any small error, so okay, due to that each other cannot sue on each other. If on the basis of performance, the word executed means the work has been completed, performed. In that case, the contract will be valid and the counterparty should pay the consideration. Okay. Executory means either it has done wholly or partly. The work has been completed or it's on the process. Okay. Consideration is reciprocal promise to be or to be performed in the future, partially performed or wholly unperformed. Example, your contract, as per your contract, construction contract. So if you perform 30%, 30% of work, I will be paying from the contract price 30% of amount. On the basis of your performance, partial performance, the amounts will be released on partial basis. Okay. So that executory will have two. One is unilateral, one-sided contract in which only one party performs his obligation. Bilateral, where obligation of both the parties is outstanding. Still, the contract has not been started. Okay, whereas here one person has already performed his work. Clear? Since there is no entry below, so the question was, yeah, minor cannot enter into a contract, but the guardian will be appointed if the minor is entering into a contract. Okay, guardian will be there, but if on some purpose or some intention he has hide his age and pretending to be as a major, that case under relief act, they'll be liable to restrain whatever the benefit has been received. I'm saying if he has not hidden the purpose. So the first case, Damodar Ghosh has told that he is a minor. Even though knowing the fact, the person has agreed and given lend the loan. Kindly one more time clarification. Okay. Here, first case, the fact that Damodar Ghosh was a minor was known by Brahmadat and his agent. Okay, even knowing the fact, they paid the loan. They gave the money to Damodar Ghosh. Okay, this arrangement, this contract was known by Damodar Ghosh and wrote a letter that this contract is void. Since he has not accompanied with any guardian, you are given directly to the amount to the minor. This contract is not valid and is not liable to pay since he is a minor. Okay. So in this case, first case, the fact was known by Brahmadat. Even after filing the case against the Damodar, the court has dismissed. The capacity to enter into a contract was major. Okay. And even the contract was not entered with the guardian. Okay. So, and after that, the relief also cannot be received. The fact was already known. Since he has not misrepresented himself in first case or for any purpose, he has not hidden his age. But in second fact, if the Brahmada didn't knew that he's a minor, he has given or he has pretended to be a major. In that case, the relief act under relief act they can claim. Okay, the whatever the benefits, and I'm not saying the interest parts. So what he had received the amount, he can restrain. Okay, yeah. So on the basis of formation, there can be either written contract or spoken oral contract, then implied contract, either by action, conduct of parties, or course of dealing. Okay, so implied. So example, so one company called Carbolic Smoke Ball. This is a pharma company. Okay, so he will give an advertisement that if you take a certain medicine, one type of medicine, you will not be attracted by influenza, influenza, cold, etc. Okay. So for that, the condition, whatever the conditions are prescribed, you should take the certain ml, etc. Okay. And it was publicly announced that the public announcement, if anything happens, even after taking the medicine, okay, if you're suffering from influenza or cold, Okay, you are liable to receive the compensation of 100 euros. Okay, 100 pounds. Okay, in that already they had announced that they have already kept the deposit of 1,000 euros in the certain bank. Now the person called Car- Carnel. Okay, he followed all the instructions given by the company. But even after following the instructions, okay, he was suffering from influenza and cold disease. So now he had filed the case against the company. In such case, is he liable to receive the compensation? There is no contract. Yes. Why? Spoken. Yes. It was given to all. It is deemed to be contract. Yes. So the company has advertised, okay, after taking this medicine, you will not be attracted by influenza. And also, they had told that if you get attracted, okay, you will be receiving the compensation of 100 pounds or 100 euros. And next, they are already deposited in certain bank. Okay, they are claiming that their medicine is so well that you won't get suffered from any cold except you follow all the conditions. Okay, when he had followed all the conditions, he had suffered, he filed the case. Okay, the company's point of view is that it was a general ad and vaguely given the advertisement. Okay, and they are saying that it is not a promise to or a offer to a particular person. The next, the court decision was, since you were claiming that that the person does not suffer with any cold or any other disease, and you have already proved with your market advertisement that you have kept the deposit for for any compensation. Clear, implied. This was the uh, case Carlyle versus Carbolic Smoke Ball. Yes, the company given the assurance through the advertisement. Based on that, the company must pay. Yes, the company is liable to pay. That is implied. So, implied. Implied by action, conduct of the party. The company had given the certain conditions that you need to consume the medicines 3 times, 4 times a day. Example, I'm saying. Okay. Conduct of the party. The party had conducted has the instructions from the company course of dealing. Okay, the proposal or acceptance otherwise than the words, it's called implied. Okay, so the company had given the offer and have accepted all the conditions written in the that medicine pack. Okay, then it will be as an implied contract. Quasi contract, not an actual contract, but created by law under certain circumstances. So, can I get any example for quasi contract? Example, assurance given. Okay, just one example. So, example, if I lost some goods, the theft had happened. Okay, the goods were lying in an ex company, ex house. Now the X is liable to give back the goods to me. Theft had happened, the goods was, yeah, cost is indirect. Yes, he is liable to give me. Okay. Otherwise, I can file a case against him because the goods are in X house. Okay. Even though there is no actual contract, but created by law under certain circumstances like loss of goods. Okay. The next, tacit means silent. Tacit contracts, it is a situation where contract has to be understood from the conduct of the parties. Terms and conditions are known. No use of words or spoken. Okay. The through through the terms and conditions. So I'm following. So there is the contract is already implied. Like example, Carlin, he had followed all the instructions. Okay, when he's following, it's automatically implied that he has understood, and there is no like what giving the written acceptance. Okay, e-contract is a contract which is entered through electronic means such as email, and even now you are getting what stamp papers also online. Okay, on that basis also agreement can be made. Next, proposal. So what is offer or proposal? Repairing watch shop owner failed to repair, liable to pay. No, he's not liable to pay. Either he need to return the item. If it is lost, he is liable to pay. Online contracts, yeah. Yes. So what is offer? Offer, what is offer? What is offer? What is offer? So one party offers, conduct, accept or reject. That is other party. Offer you whether you want to accept or reject. It is requirement for formation of contract. Yes. For means gift. No. Conditional proposal made by a buyer or a seller to buy or sell. Yes. Yes. Offer buy one get one. So if you are purchasing one shampoo, you'll be getting the free of another shampoo bottle. The condition is you need to purchase one. Reward, no wrong committed, no damages. So my offer must be capable of creating a legal relationship. So if I'm giving an offer or proposal, okay, there should be a legal relationship, and every offer, okay, one must be certain, definite, and not vague. Okay. Offer must be communicated to the offeree. So, in the case of Lalman Shukla, the offer was not communicated to Lalman Shukla. Okay, he, as his duty, he searched the nephew and brought him. But if the offer was communicated, you would be liable for the reward. Since the offer was not communicated, okay, offer must be made with a view of obtaining an assent of the other party. Okay, and offer may be specific or general, like carbolic smoke ball case. Offer may be expressed or implied. Parallel had implied. So he has expressed and followed all the conditions. Offer must contain a terms of non-compliance of which amount to the acceptance. Okay, that is Lalman Shukla. So non-compliance. So he had non-compliance of which would amount to the acceptance. So he had claimed he had certain terms. He had claimed and complied with all the conditions for which was laid down by the company. Okay, so he don't want to specifically give the acceptance. In that case, then offer acceptance when the person to whom the proposal is made signifies is assent thereto, when the proposal is said to be accepted. The proposal, when accepted, becomes the promise. Okay, the legal rules for the valid acceptances: acceptance must be absolute and unqualified. Okay, okay, there should not be a conditional acceptance. Okay, an acceptance must be given by a person to whom the offer is made. Then acceptance must be communicated, prescribed mode, and within a specified limit. Okay, and mere silence is not an acceptance. Acceptance by way of conduct. By way of conduct is, so the general offer was given, but the person Carlyle had accepted, and he had conduct means he had implied what followed all the conditions. In that way also, it is an acceptance for the offer. So next, acceptance. Explain the conditions of the acceptance. Okay, here it should be an absolute and unqualified uh, acceptance. Okay, acceptance must be given only by a person to whom the offer is made. Okay, in Lalman Shukla, it was a general offer, and he had a condition. Okay, the condition is that you need to follow that, consuming 4 times a day or for 3 years for specific period, so you will not be affected by any cold. Okay, and here the one more condition for this case, acceptance by way of conduct. Carlin had accepted the offer, even though it is a general offer. He had accepted and he had followed the conditions laid by the company. When he had followed the conditions, it is mere to be an acceptance. Okay, and mere silence, it's not a acceptance. Okay, when the offer is made, I have not given the any, I have not communicated, I'm just silent. In that form, it is not an acceptance. The person to person differ. Yeah, the person to person differ, but here in general offer, the conditions were laid already. He is liable. Okay. See, there was a general offer of buy one get one, buy one and get one. Unless you buy one item, you won't get this free. There is a condition, right? So when you buy one, you that will be given as a free item. So if you are not following the condition or any of the conditions laid by the company, that would not be an valid offer. I mean, sorry, that won't be applicable to you. So you can't get the free item. So communication of offer. Okay, when the offer gets completed. So offer gets completed when it comes to the knowledge of the person to whom it is made. So the when see here the offer that in Lalman Shukla, the offer was not known by the servant. Okay, and he has not even accepted. So it was not known. Acceptance against the offer when it is put in the course of the transmission to him, offerer. Okay. Then against the offeree when it comes to the knowledge. When the offeree should know know the fact that what is the offer made. Okay. In that point, the offer gets completed. So when you can cancel offer anytime before the acceptance. Before the acceptance, anytime the offer can be cancelled. Okay. Acceptance is complete as against the offerer. Okay. So the next is acceptance is completed against the offerer. Acceptance. So anytime before the acceptance is completed. Anytime before the acceptance is, the offer is made, but he has not given his consent, okay, towards the offer. Okay, anytime he can backward. Then when the communication of revocation, cancellation gets completed against the person who makes it, the person who makes the what offer, when it is put in the course of transmission so as to out of the power of a person makes it. So it should be communicated, okay, before it would be accepted as against the person to whom it is made when it comes to his knowledge, okay, to whom the offer is given. Okay, the revocation of the offer should be communicated to the offeree, okay, before it gets accepted. Clear? And modes of revocation. So cancellation, either notice of revocation, okay, it can be given by a post or mail, electronic medium, or if the offer is for certain period, okay, then after the certain period it will be revoked. Example, you will get many offers like Christmas offers, Amazon end of season sales, etc. So it is a certain period offer. After the certain period, that is for 1 week or 15 days, after 15 days the offer won't be valid. Okay, lapse a certain period of time, that are insanity of the person who had made the offer. Okay, he has died. Okay, before getting the acceptance. In such case, it can be revoked. Non-fulfillment of the conditions. Okay, so whatever the conditions are there, when these conditions are not fulfilled, the offer can be revoked. Okay, counter offer. So on the counter, so I will give an cash discount. Cash discount, if you are purchasing, example, for the worth of 2 lakhs worth rupees goods, but if you pay now, I'll be giving you the 10% discount. But if you're paying after 2 months, 3 months, there won't be any 10% discount. Such case, counter offer. So unless if you pay immediately, the offer is valid, else it gets cancelled. What is consideration? The consideration, either in money or money's money's worth or kind. When at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstain from doing. Okay. So one person has given the offer, another person has accepted. When the work has been completed, or or in the process of executory contract where the partial work has done, so the other person is liable to pay. Okay, so whatever the promiser had done to him, such an act or abstinence or a promise is called consideration. Legal rules. The consideration must move at the desire of promiser. So the promiser who makes that, if you give the goods, okay, within a certain period of within a certain period, I will be paying immediately. If you are getting the goods, okay, or work done after a delay of certain period, 14 days, 15 days, so the payments will be delayed with 15 days accordingly. Okay, the consideration can be past, present, future. Consideration may move from promisee or any other person. Consideration need not be adequate. Okay, 2 times. The consideration must be real and not illusionary consideration. Consideration must not be unlawful or immoral or opposed to the public policy. Okay, so if you kill Mr. X, I will be giving you the a certain sum of money. So it should not be unlawful. Okay. Yeah. Yeah. The consideration may be in cash or kind. Bank guarantee. Yes. Made by offer is an offer which is made by opposite person. Yes. Not nothing. So if you're seeing, so in order to secure, next, there is an exception to Doctrine of Privity Act. Okay. What is Doctrine of Privity Act? What is Doctrine of Privity Contract? Even a barter system of goods is a contract. If not a party to contract, you cannot claim the benefits. What is Doctrine of Privity Contract? So there is an HUF. HUF. Okay. And Mr. A. These cases will be there. Okay. So HUF, under HUF there was a property. Okay. Like Mr. A. Mr. A is a karta. He sold without the knowledge of the family members to Mr. X, to Mr. A. Such case. Question is, members of the family can file a case. Can the members of the family file a case? Yes. Yes. So, in case of Doctrine of Privity Act, if it's a Doctrine of Privity, means Doctrine of Privity is only party to the contract. Party to the contract can file a case against the other person, whereas there is an exception. HUF, without the knowledge of members of the family, sold the property to Mr. A. Such a case, the third party means the members of the family can file the case. Okay. So next, one more is the trustee has sold the property of the trust. Against the trustee, the case can be filed. There is no acceptance of an what trust. No. Why no, sir? Why no? Why no? Mix legal attract. So in the case of trust, there should be a mutual understanding when you're disposing of any property. So if you're enforcing, or if you're adding any other services in trust, in the case of trust, the committee, the acceptance of the committee should be there. So one person is a trustee. Okay, he has sold the property without the knowledge of the committee. In that case, he will be liable. Yeah, the case can be filed against him. That is the third party. The committee members can file the case. Okay. This is the exceptions. What Doctrine of Privity Act? Yes. Other members' approval to be needed in the case of trust. Okay. Trust, family settlement, example HUF, without taking the consent of other party. I'm saying of HUF property, not the individual property. Okay. So marriage or contracts, in certain cases, marriage or contracts arrangements. Okay. In case of assignment of a contract, acknowledgement and estoppel, and in case of convenient running with land and contract entered into with through an agent, the main person, what can be sued? Exception to the rules, no consideration, no contract. Okay. So with the what natural love and affection, so I'm giving the my what I'm gifting my property to my husband, my son. So there no consideration, no contract, but the gift deed is there. I'm just registering and transferring the property. Okay. Compensation for voluntary services. Okay. The next, promise to pay time barred debt. So the insurance people will cover the businesses if any you have any time barred debt. So they promise to pay you for the sustain of your business any debts. So more than 6 months. Okay. Agency can be created. Completed gift. Bailment. So I had given my bike key to my friend to use the bike. Okay. So after after a specific period, will be liable to return back. But there is no acceptance of the any what monetary considerations. Explain trust. Trust. Sir, in trust, usually how the trust works. So when you're making any decisions, okay, when you're purchasing any decisions, the trust committee will be there, no? There should be an approval and that should be documented. Okay. Trustee or chairman. Chairman alone cannot take the decision and dispose of any asset of the trust. Okay. So in that case, the trust members can file the case. That is exception to the doctrine of privity. Only to the party to the contract, there is no necessary only to the party to the contract to file the case. The committee members can file the case because the property would be, example, the chairman can sell the property of trust to his wife or as what wife or children's, since it would have some commercial value. Example, I'm saying. So in that there should be a committee decisions to be documented. Yes. So performance of the contract, that is either executory or executed. So if already executed means the contract has been completed, the counterparty is obligated to pay the consideration. Okay. The contract is said to be performed when the party to the contract either performs or offer to the perform their promise. Okay. So actual performance where both the party fulfill their uh, obligations as per the contract. Okay. Tender of performance or attempted when the promise or the promiser offers to perform, but the promisee refuses to accept the performance. Okay. So when the contract gets discharged, actual performance, the work has been completed upon performance. Okay. Or the counterparty refuses to accept the performance. Okay. So in that time, the contract gets discharged. Okay. I have agreed for an example for the construction of a house. So the materials which was brought from the contractor, it was not a good type of material. So any time the house can get the crack on the walls. So that time I can refuse it. So even though the contractor is ready to perform, but the person, I'm refusing the contract because he is using the low graded materials. Okay. In that case, there is a discharge of contract. Okay. Okay. So the discharge of contract can be made either new contract novation means the what I can say, 1 second. Okay. New contract like lease agreement where after 11 months you want to continue the contract. So new contract can be done either new contract or alteration. So I'm paying extra 5% additional rent and making an additional alteration in my old contract. Recession, taking back the decision before the performance start or agreement has come to end, where where I got to know the person will use low graded materials. So before start of the contract, I'm ending the contract by communicating. Okay, remission. acceptance of the in lesser sum. So I made a good construction, but now the party is not paying the money. So even after 6 months, or even after 1 year, the party has not paid the consideration. In such time, the other person can at least, so he will say, okay, at least you are not ready to pay me full amount. Please clear at least with the cost or 70% remission, waiver, releasing from the obligation. Okay. So in that time, that there would be a mutual agreement. So that time the other person may pay the 70% and come out of the contract. Discharge by lapse of time, like Amazon sale. After 15 days, end of season sale, you can't have any offers or you can't have any sale of item. Okay. Discharge by impossible performance. So you're not binding to the contract. Example, like killing and Mr. X. Okay, operation of law, discharge by operation of law or breach of contract. So I had told that I had a condition that you need to give certain what example water bottle, like yesterday's water bottle condition, that my water bottle should keep my water as warm. Okay, but you have breached the contract, right? You have supplied me a wrong water bottle. In such case, there is a breach of contract and it can be discharged at any time. Okay, I can return back the bottle or ask for the pay back my amount. So next, special type of contract. One is contingent contract and quasi contract. Contingent. Contingent, a contract to do or not to do something. If some event collateral to such contract does or does not happen. Okay. So quasi, it's an obligation imposed by law. Loss of goods when it is found out. Okay. Even though there is no contract, the other person who had got the what goods is liable to return back the goods. Okay. Then next, contract of indemnity and guarantee. Can you get the difference? What is indemnity? Return of goods. Yes. Contingent contract. Like example, I told no for Mr. X. Mr. X, I'll be paying 8 lakhs as a bonus. Bonus after 3 years. After 3 years. This is not the salary. This is a bonus. After 3 years, if we retain in the company for 3 years, for a period of 3 years, after 3 years, I'm paying. So during my first year, I'm not sure whether he'll stay with me or not, right? With my company. Okay. So the contract to do or not to do something. Okay. If some event collateral to such contract does not or does not apply. My condition in my contract at the time of joining for the company that Mr. Hex, if he stays in my company, I'll be liable to pay 8 lakhs. If he does not stay, after 1 year, if he is going to other company, I'm not liable for this. It's a contingent contract. Marriage covered under the contingent contract. How, sir? Marriage is a deemed agreement. Save others from loss. So marriage cannot be contingent contract. So if you marry me, I'm paying you so much, or I'm purchasing you the gold jewelry. Yeah, if you're going for, yeah, as per law, you need to pay when you're going for separation. When you're together, why there is any law obligation? On voluntary basis, you will be paying. That's it. Marriage is under religious and special act. So indemnity. Indemnity means against loss. Example, your life insurance. Life insurance. So nowadays, for housing loan, Have you come across housing loan? They have an agreement, insurance, housing loan. So when you have applied for a loan, they'll ask insurance for that. If in a case the person who had taken an insurance as like sudden death or insolvent, sorry, for a sudden death of that particular person, the insurance company will be liable to pay the balance housing loan amount. The dependents are not liable to pay the balance EMIs to the bank. Example. So whereas guarantee, so I have obtained the housing loan. Okay. Since my assets were not enough, so one person, like say my brother, he had given the guarantee on the basis of his property to me. Okay. But I failed to pay my EMI. Failed to pay my EMI. In that in that case, so when I am not paying the EMI, so the bank can approach my brother to recover the amount. Clear? Yes, protection against the damage or loss, especially in the form of promise to pay. So next, I'll have a brief, okay? Special relief, okay? Where the special relief is when you had suffered a huge loss, okay? So in that case, there is a relief, okay, under the act, and that act came into force in 1963. So when recovery of the property, possession of the property, without your knowledge, okay, an ex person has acquired your property and is not giving your property in that case, okay, specific performance of the contract, okay, like have given a good the condition was to provide me the structure, building. So even after completion of my contract, when I have not received the consideration, that time under Special Relief Act, I can file a case. Okay, or rectification of instruments. Okay, any frauds, that rectification can be done. Recession, cancellation of instrument, declaratory of the decree. So court can intervene, okay, in few cases and give the relief. Okay. Example, Damodar Ghosh. So, okay, if he had I did his identity that is a minor, okay, the court can intervene and restrain the benefits received by the minor, okay, and injunctions. So the specific relief act, when it is breached, compensation damage, either compensation damage should be given, or other specific relief act where recovery of possession, if it's a immovable property, then specific performance contract rectification, these then to be breached, okay, injunction from the court, either temporarily or perpetual. No, insolvency is not covered. Why can't family members, as they are enjoying? No. See, family members, if they are enjoying. Example, in this case, what I'm saying, if the person who had received the insurance, okay, so the nominee will be right, or the property has been transferred to that person. Example, father had taken a loan, okay, father dies, okay, but he had not taken housing insurance. I'm not saying life insurance, I'm speaking about housing insurance, housing loan insurance. A new concept is there, okay. Son is liable to pay the housing loan, okay. If the insurance was taken in that time before his death, son would not be liable to pay the any remaining balance EMI. So the insurance company will pay the balance EMI. So evening will be starting with relief act. Clear? So any questions?
Madam,
Yes, sir.
As a just 5 minutes gap to you, just may I
Yes, sir.
intervene for 2-3 slides? May I run 2-3 slides with your permission?
Yes, sir. I'll...
Just 5 minutes.
Yes, sir. Yes, sir. I just
Okay.
stopped my...
Okay, members, any questions regarding this session with madam? You can put it in the chat box. Okay. So just now we will go and see what is law. Okay. 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 Madam is very clear. Okay. 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 When there is an insurance facility, why guarantee is required? Okay. Okay. That will come up. No problem. Okay. So now just let us come to another part of our learning. Is my screen visible? Madam, is my screen visible there? Hello?
Yes, sir. Yes, sir.
Okay,
Yes, sir.
okay, okay. See, just what are the most common regulatory compliance requirements for business? So we must know what is compliance, what is regulatory compliance, and what is a business regulatory law. So we must know what is compliance with regulatory laws in specific business. So what are the most challenging issues you face in business regulatory law? Compliance. Why is business regulatory law compliance is so important? So now, okay. So what is law? Can anyone say whether I am correct? Whether my words are correct? You have to endorse me. If I am wrong, you have to say why, how I am wrong. What is law? Generally, it is said law is merely a common sense. So, we cannot do whatever it comes to our mind. So, as a responsible citizen, we must carefully know whether our common sense is listed in the book of law. If so, in accordance to that common sense, how we have to behave. So, that is law. So, government, okay, Krishna Kumar, law means statute, act, rule, regulation, order, ordinance, and point of view of legislature. Definitely. But from where it comes, okay, from where it comes, it is a common sense. Whatever the common sense and widely recommended and accepted and put to use is only the act, rule, and all the statute. In accordance to that, I will come to you that slide and all other things. Because government cannot recruit all. It cannot give employment to one and all. Okay, but it can diligently make ample opportunities to earn your food and shelter. So if you are able, you can earn. If you are unable, downtrodden, then government will take care of you, of your food and shelter as a underprivileged. So we all feel whether we are privileged or underprivileged. That is our common sense. Okay. So government is a lawmaker. Okay, it enacts the law. The consumer citizen is the original and the ultimate contributor, because a consumer alone will pay the tax. But in between, the department will sensibly enforce whether the taxes from the citizen, consumer citizen. Why I using the consumer citizen, I will come to you later. So the taxes of a consumer, whether it is reaching the government for the sake of welfare of society, is sensibly monitored by a regulator. That what we call it as a department, tax department. So what is the duty of the trade and industry? The trade and industry is not doing any favor, under an obligation of an opportunity. Okay, business is not a charity. Business is an opportunity. Of course, you can make it as a charity, but it has its own way of handling. So trade and industry must understand they are under the obligation of opportunity. They are merely a collectors of tax, nothing more. They are not paying anything out of their pocket. So where we are, practitioners, we are all proposed as non-litigant propagators. Okay. So sensibly, before going for any litigation, we must see what is the best ways of coming out. Okay. That's what actually the majority of complaints takes care. Then, Madam has told what is contract. So whether you are endorsing all these points, whether you have catched all these points, the essence of a contract is an offer, an acceptance, a consideration, execution, and then that realization. Is it okay? Any confusion in this one? Offer. What is offer? That should be a legal. Acceptance. That should also be a legal, but with free consent. Okay. Then consideration. If it is to be called as a contract, there must be a consideration with a valid evidence. It may be oral or it may be a hard prints, but that should be a evidential. So then what is execution? Whatever you promised that you have to process in accordance to your promises of offer, acceptance and the consideration. So you have to perform it. That is called execution. Then only we can think about the last limb of the contract, realization. Without proper evidence and without proper acceptance and offer, for any consideration, if we execute any act, any performance of process, if we don't get the money back, so you cannot file any suit in any court of law, because when once you file a case against anybody, then the courts will ask you all these process. Then it may take some time and your case may get automatically dismissed. So funniest, we may feel very funny. Business is a contract, whether marriage is a contract. So in this angle, if you see whether marriage is a contract, so madam has told that case law, okay, at that time there was no law. So that what actually, that is the first incident which made the land to enact and enforce a law on the people, how they have to behave. So they are totally living together and they are doing on their own. And when there is a hardship to someone, they have, okay, pursued their constraint to the court. Then court said, where there is no law, how you can come and approach me? So that it made to enact the Marriage Act. So it is an arrangement, it is an agreement of living together, because we are not born, we are not blood relatives. Okay, marriage. Why I am putting is just only for a just our change of our mood and other things. So Marriage Act, we have to, you must know what is Marriage Act. There are several Marriage Acts. Okay, husband is liable unless he notifies specifically. He must specify what he is not going to perform. So that is law. Wife is not liable for anything which is not specifically notified. So India is very famous for Nari Pujyate. So wives, Indian wives have major security. Okay. So whatever the imperformance of a husband is always a boon to a wife. Don't make it as a case. Just take it lightly. Okay. I am going in a very humorous mode. Okay. Sense of humor. So all marriages can be sued if you are not registered. Please take it from me. Any marriages can be sued in any court of law by the third parties without a proper registration. Can anyone say why there is a need of registration of marriages? Generally, we see the marriages are registered. Can anyone say? Text here. Whether we are going to register our marriages or not. Whether we are registering, where you are registering. It is very funny but true. Yeah, definitely, sir. All will fun. If everything ends well, it is well. If nothing ends well, that is the hell. That's what actually the common sense. Okay, sub-registrar. Okay. 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 Sub-registrar, the registrar of marriages. Okay, not compulsory. Okay, not compulsory. In case of a litigation, you have to prove there is a marriage. How you will prove it? How you are going to prove there is a marriage has occurred? Who will come and give the witness? Okay, Hindu marriages are there, several marriages acts are there. Several. Okay, so register of marriages. Generally, whenever okay, we go to foreign countries, okay, on visa, when there is an obligation to prove you are a wife and you are a husband, then generally we go and register our marriages, and then only on the certificate of marriages, the embassy will allow you. Otherwise, you cannot go out of our territory. The other territory will not invite you if you are not a valid husband and wife. So, even in certain cases, okay, after any period, you can get it registered. I can register my marriage. I married in the year 1995. Now I can go and register my marriage. But it is not necessary because there is no litigation. Everything will come only where there is a hardship and the law will take care of it. So read Marriages Act before getting married. Okay, if you are all married, don't worry. If you are not married, read the law carefully. So read, discuss, get trained and understand before you act or perform. Not only for the marriage, that what we call it as no loss, no loss. So that what actually you can see this picture. Is my picture visible here? What it is? It is a registered trademark. It is a registered and valid orientation course given to the chartered tax practitioners under NCBET also. No loss for no loss. There is a website. You can visit noloss.in also. You can get exhaustive details. What is law and what is no law. No loss, no loss. Just it is a tongue twister made into text and got approval of the government. Generally, we go to the lawmaker and make the representation. Accordingly, the lawmaker will give a law. So, the law is enacted in the parliament or in our legislature house, but the same will be tested in the hands of courts. So, that what actually we generally call it as by the people, of the people, and for the people. This is all what actually we have to learn. Okay, madam?
Yes, sir.
Thank you, madam. Thank you.
Thank you.
Okay, all these PDFs will be shared. Don't worry. You will get all this exhaustive presentation papers as well as your LMS, everything you are going to get. Do you have any doubts before going to the Relief Act? Now we all gone through what is contract and all other things. Madam? Madam? Connection lost. It's already 7:30. Kitto, call the madam, whether madam will come. Only timer out is there, 7:30, the time out.
Hello.
Yeah, call the madam. Just check
Okay.
once.
Ah,
The connection is lost here. Now that the relief act we have to, if the time permits, we will take. Otherwise, that can be covered in the afternoon. I think better. She left, but left or timeout, because there will be a timer in the Zoom. Everything is automated nowadays. That's what actually carefully I kept it up to 8. But there it might have come as 7:30. Okay. So any questions, dear members? Do you have any questions? You can raise your hands and we can discuss. Otherwise, you can text here or we can meet in the evening also. Muthukumar Swami sir?
Hello?
Ha sir.
Yes.
So is it useful?
Uh, very much useful.
Whether it is required?
Compulsorily.
Okay.
You, you have done a very good job.
Anantana? Ananta Padmanabha.
Yes, sir.
What do you say?
Fantastic, sir, because our fraternity requires such training to educate our members and follow the ethics in our profession.
This
They
is
should
the
know
basic essence, what actually we lack everywhere.
Yeah.
For your kind information, officially I am telling you why government is making the e-invoice, you know. This OTP. You may know OTP. That is one-time password.
Password.
One-time password is a contract. That is
Yes.
a contract. That is an offer and acceptance. And your acceptance and assurance. So based upon that, all your returns and other things are filed in the similar manner. Because to reduce the litigation, government is seriously trying to make an invoice to automatically go and get credited into the details of the recipient itself. So we must be very careful. Do you agree?
Yes, definitely.
Yes, sir. So, anybody want to talk? Business regulatory law, NGOs and yes, that all will come, sir. NGOs, FCRA, FERA, okay, FEMA, FERA, everything will come to the best extent of our practice. All will come. You will also get the minor acts and all other things. Pooja madam has come. Okay, just we will ask Pooja madam. 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 It is already 7:35. Madam.
Yes, sir.
Shall we cover it in the afternoon or will you make it now?
We'll cover in the afternoon. I mean evening session, sir.
6 o'clock evening. Shall we take it up? That relief act and other things.
Yes, sir.
Okay. Sorry, I think I have come without a schedule. I have taken your 10 minutes, sir. Okay, dear members. We shall all assemble sharp 6 o'clock in the evening to know about the Relief Act and other related subject to business regulatory law compliances. So thank you one and all. Happy day, happy morning. Thank you, Madam Ji. Thank you.
Thank you, sir. Thanks.
Thank you.
Just the meaning I need. Relief fact. No answer. To give some concession, okay? To reduce the rate. No? Amend the law relating to certain kind of specific relief. Remedies. Where relief act, where your rights have been hampered or to be hampered. means where is my slide is, see, 1 second. Yes. Yeah, if party suffers due to loss, provide compensation. Yes. So relief act, where your rights are to be suffered. Okay. In that cases, relief act has been enforced and to provide the compensation. Okay. So the Relief Act provides remedies for any person, civil or contractual rights which has been violated. Where a specific Relief Act applies to whole of India except state of Jammu and Kashmir. So where here the contract which has been breached means your rights has been hampered, where to be breached means it would happen. Okay, in that case injunction from the court will be there either temporarily or perpetual. Okay, where when the contract has been breached, there will be specific relief either on the basis of compensation damage or recovery of possession. Okay, so example, you have sold the goods. So even the party is not paying you. Okay, in that case, either you can take back the goods, okay, or file a case for compensation. Okay, and specific performance. Okay, I had a conditional contract where I had given a specification where I had given a specification and that goods still has not been delivered within a due date. In such case, the contract, in such case, that what compensation can be received. Next, rectification of instruments, where there is what mistake or misrepresentation. In such case, there would be a chances to recover or change the instrument. Okay, rectification, cancel. Just 1 minute. Sorry, I had received some inquiry. Okay, so next, okay, in next case where recovery on specific relief when the contract has been breached. Okay, if it's movable or immovable property. If movable property, you can claim the compensation or get back the goods, whatever the goods has been given. Okay, so in such case, the specific and immediate recovery of movable property can be obtained by the plaintiff under the following cases. When the defendant holds it as a trustee or an agent. Okay, in such case, you can take back the goods. Okay, when the compensation is not adequate, and adequate relief when assessment of damages is difficult, when the possession of things claimed has been wrongfully transferred, either by misrepresentation or any other way, when it is wrongfully without knowing, okay, the goods has been transferred. Example, as I told, without the consent, okay, in an HUF, without the consent of family members, if the goods has been sold, in such case also can be taken back. Okay, so next is if it's an immovable property. Immovable property, so without his consent, it has been transferred. Okay, so otherwise, due to course of law, okay, he is entitled to recover the possession of the property. Only one condition that he need to file a case within 6 months. Six months from the date of disposition. Okay, hence he cannot file the case. Then again, the suit cannot be against the government. Example, if you have an house or a plot in the main road. Okay, so that time if the government has acquired a certain part of your place, in that time you can't go against the government. Okay, and you can't file against the government. Okay, for road widening. No appeal is allowed in the appellate court, or no review of petition is maintainable. Okay, if it's against the government, if the plaintiff has parted with the position voluntarily basis, if on voluntary basis, if he has transferred the goods, in such cases the suit cannot be filed. Okay, so next is a specific performance of a contract. Okay, the contracts which can be specially enforced, the contracts which cannot be specially enforced, persons for against whom the contract may be specifically enforced, or discretion of court of law. These are the divisions in the specific of performance of contract. So one question. So I had an old antique jewelry. Okay, old jewelry. I had many sentiment on that. Okay, so now my son had sold that. My son had sold that. Can I take back this, giving like whatever the consideration, and take back this jewelry back? No. Why? Without my permission, the jewelry has been sold. I have some interest on that. It's from my great grandmother. Yes, yes, I can take back. Yeah, even though transfer of goods is there, you can, yeah, I can request. Yes. So, here, okay, when specifically perform, when there is no standards of ascertaining. No. Ascertaining certain or actual damage caused by the non-performance of the act, or when the compensation in money is inadequate. Since it is an old antique jewelry, okay, more than market price, it would have a value. Okay, but I have recovered only the market price of today's gold price. Example, okay. If in case of breach of contract, if it's an immovable property, compensation in money is inadequate. If it's a movable, compensation is adequate relief. Okay, however, in case of movable property, the following cases compensation is inadequate relief. Okay, whatsoever, even though he has given a correct price as of today, but there would be some sentiment, or due to that antique, the cost may be more. Okay, where it is not an article of during ordinary course of business, where they consist of goods which are not easily obtainable in the market. Okay, where such goods are special value or interest to the plaintiff. So where the property is held by defendant as an agent or a trustee. Okay, so I can take back the goods, whatever the monetary terms he has value, we can repay, we can take back the item. Clear? But I'm not gifted. Without my knowledge, he have taken and sold the item. It's an example. Okay. The contracts which are not specifically enforced. Okay. Where there is an adequate relief. Okay. And the contract which is indeterminate. Okay. So in that cases, you cannot enforce and claim the any relief. So example is, so when which example? Damodar Ghosh. So he knew that the person is major. Okay, the person is sorry. The in Damodar Ghosh case, Brahmadat knew that Damodar Ghosh is a minor person. Okay, he is in incapacity to enter into contract. Even though he knew the fact, he had entered into contract. The contract is void. So whatever the money he had paid to Damodar Ghosh, that cannot be retained. Okay, because there is an facts. Okay, in that this relief act he cannot, under this relief act also he cannot exercise. Yes, so the person for whom for or against the contract may be specifically enforced. Who can sue the specific person? A party to the contract, representative in nature, and where the contract is a settlement of marriage between the members of the same family, HUF. Okay, a reminder man of tenant. Okay, the revisioner in possession, a revisioner in reminder, or new amalgamations of the new amalgamation company, or a company on behalf of its promoter. Okay, so next, who cannot sue for a specific performance? No, who would not be entitled to recover the compensation is incapable of performing the contract. They are minor, unsound person, or disqualified from the act of, or violated any essential terms of a contract. Okay, with the essential items. Okay, there should be a free of consent, and it should not be with the force. Okay, with the any pressure. Okay, who acts in fraud of a contract, it is void ab initio. Who willfully acts at variance, okay, with relation to the establishment. Variance means pretending to be the part of the company. Who fails to show his readiness or willingness to perform the essential terms of the contract which are to be performed by him. Okay. Next, discretion. Discretion and power of the court. Okay, so the court can intervene and interpret and give the decisions. Okay, if the plaintiff has suffered a lot, so in that cases the court may take the proper decisions. Okay, where the contract gives an unfair advantage to the plaintiff over the defendant. Okay, where the performance of the contract would involve some unforeseen hardship, okay, on a defendant. It's not performance. So example, so I was the service provider to the hospital, service provided to the hospital, providing the medicines. Okay, so during covid there was a huge demand and the stock was not available with me. Okay, the court has filed a case against me that not providing the stock in time. Sorry, the hospital has filed the case against me that this man wantedly creating the shortage of medicine. Okay, there was a fact. Okay, with me I have a fact that my stock statement, and in my returns also I have no shortage of stock. In such case, can I get the relief? No. Why? The hospital has filed against me that I'm not providing the medicines to them. See, normal course I can, yeah, breach of contract, yes. Yes, I have the evidence, my stock statement. I don't have the particular items. There was a huge demand to particular item, say crocin. In such cases, the court can intervene and provide the relief to me. Why? There was an unforeseen hardship. During COVID time, there was a non-movement. Okay, we were not able to move from one place to another place. And sudden shortage. There was a huge demand for a particular item. So when there was non-availability of stock, how can I supply even though there is a demand? Even though there is a contract, I can't supply. Non-performance would not cause any hardship. Okay, when there is an hardship to supply, the court can give the in favor of myself. Okay, where the defendant enters into a contract under circumstances which amounts in inequitable. Okay, so what clear? Yeah, abnormal situations. No intent. No. I had an intention to supply. For me, what is there, I'll be supplying. But I don't have the stock. The opposite person is not even understanding and listening to my words, right? In that situation, even though he files the case, there is no use. Okay, the court is in favor of the pharmacy. Example. Next, rectification of instruments. Okay, so two parties came into understand and have done the agreement, I mean contract. Okay, but they were not able to sue against each other if in future. So in that case, in that case, they'll have an option to rectify the contract. Okay, when when through fraud or mutual mistake. Okay, they entered into a contract, but at the end, after few months, they got to know that there was a mistake. Okay, so example, technical mistake where I had a building, so I wanted to rent my building to the school to run the educational services. So I had given them that for an rental of 3 lakhs per month. Okay, so this was there, and every year, based on the admission, so you should give certain percentage of rent as an increase in rent. Okay, this is my case. So I have a building I had given for a school for an education. Okay, the rent is 3 lakhs per month. Okay, so while getting signed, due to clerical mistake, instead of 3 lakhs per month, the person who had typed, he had given us 3 lakhs per annum. Okay, as a rental income. So he missed this point. If the admission increase, you need to increase my rent. Now, in this case, can the sufferer can file a case or rectify the instrument? Students, please. Yes. No. Why? Sudesh, why no? No, why? My question is, see, I'm giving the building in the prime area where the rent for that building would be 3 lakhs, 4 lakhs per month. Yes, can rectify the instrument. Yes, as it's a mutual rectification. Okay, even though the contract would be in place, after a few months, I've seen that it is in 3 months, over 3 lakhs per annum. Okay, so this I can rectify. Okay, and does not express their real intention. There was no real intention to give only 3 lakhs per annum. Okay, either party or his representative in the interest may institute a suit to have an instrument rectified. Okay, so if the other party is not willing, so in such case, I will have a valid evidence. Okay, this is a prime area. So what is the rent there for the building, running of the business? Okay, this was a mistake. Instead of per month, they have put the per annum. Okay, so initial base agreement we can take. The court may, in its discretion, may direct for rectification. The contract may be first to be rectified, specifically enforced, no relief unless specifically claimed. Okay. Next, rescission of contract means cancel or come to an end. Okay. Any person interest in a contract may sue or rescind, cancel the contract, and court may grant such rescission if the contract is voidable or terminable by plaintiff, or the contract is unlawful for a cause not apparent on its face and the defendant is more to blame than plaintiff. Okay, but the court may refuse to cancel when the plaintiff has expressly implied or ratified the contract. Okay, example, carbolic carbolic case where Carlyle has expressly like implied all the conditions, but now now the company is saying that I won't pay any compensation. In such case, the court may refuse the company's words and provide in favor of the Carlyle. Okay, where owing to change circumstances, the parties cannot substantially restore to the position in which they stood when the contract was made. Okay, and when the parties have acquired the rights in good faith without notice and for value. Okay, so in both the parties, so all the essential elements of the contract has been fulfilled and it was in good faith. In such case, the court may refuse to cancel. Okay, where the part is not severable from the rest of the part. Only a small mistake, a minor mistake. In such cases, the court may does not accept or refuse to cancel the contract. Okay. So recession. So why the either in restoring the position, taking back the immobile example, taking back the immobile items, or refund the earnest money. Examples: earnest money and other profits, or restore any benefits received to give compensation. Next is cancellation of instruments. Okay, so when initial stage, okay, if the Brahmadat knew that Damodar was major. Okay, so even though he is giving the loan, that is void and cancelable at initial stage only. Okay, has a reasonable apprehension that such instrument is left outstanding, may cause a serious injury, may sue to have its adjudged void or voidable, and the court may, in its discretion, in its powers, so adjudge it and order it to be delivered up on and cancelled. Okay, and if the instrument had been registered, the court shall also send a copy of its degree to registration office. Okay, where there is a sale agreement of land, like an agricultural land, say for 5 lakhs. Okay, so after a midnight, so after so one law, there was a sale agreement, still they had given the advance of say 50,000. Okay, so after 2 days, so there was a news that their highway is coming, highway. So in such case, after 1 week, the cost of the land had increased to 8 lakhs. Now, can I cancel the agreement? Can I cancel? Can I cancel the agreement? Government undertaken. Yes. If yes means why? No. Okay. Up to us. Yes, can cancel the agreement. Partially. If the buyer agrees. Okay. Yes means why? No means why. My question is, I had a sale agreement and I had given 50,000 as an advance. Agreement, which is not enforced by the law. Yes. Yes, not registered. Yes, not transferred asset, only advance. Yes. One is I can return the 50,000 advance to the person. Legally not done, so can cancel. Yes, sir. Yes. Okay. So in this case, it is an agreement which is not enforced by the law. So what if I had paid and the contract, I mean, in sub-register office also it has been transferred the asset, title of the asset. What would be in such case? Can I ask? 3 lakhs? 3 lakhs can I ask from the person? You can't claim. Yes. At the time of entering into agreement, at the time of transferring the asset, I didn't knew that there would be an highway. Okay. Even though he claims or he files against the buyer for 3 lakhs, it would not be valid, because at the time of selling, he was not aware of the highway. So cancelable, where after 2 days he got to know, and suddenly the price was high, and since it's not registered, he can cancel. Okay, the court may direct plaintiff to restore the benefits taken or grants compensation. Okay, but if it's a contract, he cannot restore. And declarative degree is a specific relief that can be obtained by plaintiff against the defendant. Plaintiff is entitled to any rights. Okay, so any person entitled to any legal character or any rights of any property may institute a suit against any person denying his titles. Okay, so example, my house was there. Okay, I was not in the India. I was not in India for 1 year. Someone illegally acquired, changed and illegally acquired. In such case, can I file a case? Can I file a case? Yes. I was not in India. Yes. Any person can file. Okay. Where my title has been changed illegally without my knowledge. Okay. I can go for and file the case. Okay. Preventive. Preventive means where the court may give, okay, or temporary relief. So I know my house is in prime location. Okay, and every day the builders used to come near my house and ask for the to sell the house. Okay, in such case, so I knew that after 2 years I won't be in the India. So in order to avoid these sellers, can I get the injunction from the court? Because in my absence, if the builders illegally, yes, illegally acquire my property, so there would be a temporary injunction, okay, judicial profit, okay, where granted at the end of the suit to prevent breach of any obligation, okay, existing in favor of plaintiff. Okay, so next, granted for specific time. So I'm asking the court for 2 years or until further I return back to India. No one. So okay, either in the without my consent, they can sell the property. Preventive relief. So in case of perpetual injunction, to prevent the breach of an obligation existing in his favor, and defendant invades and threatens to invade the rights. The builder is saying, if you not give the house property, so I would do, I will what kill the X person, Y person. Your example. Okay, in that case, he can get the injunction from the court. So have a life threat. Okay, where there is no excess of standard of ascertained or actual damage. So emotional damage. So emotional threats I'm getting. Okay, where invasion is such that compensation in money would not afford an adequate relief. So, in order to leave the premise, so in order to evacuate me from the rented house, so they started to blackmail, or they started to stop supplying the water, electricity, or or like what in such cases some serious things had happened in house where the adequate some death had happened. Okay, where there was no water supply, electricity for a week or for months together. Okay, some things had happened. In that case also injunction can be brought, where injunction is necessary to prevent multiplicity of judicial proceedings. Okay, mandatory injunction. So mandatory, it is necessary to compel the performance of certain acts which the court is capable of enforcing. The court may grant mandatory injunction to prevent the breach of complied and also compel performance of request. Okay, clear? Yes. Injunction means order. Okay. Example, what I told, few people, builders are coming in front of my house. Okay, they're sending gundas also. Okay, to threaten me. So in such case, order, court order. So these people are threatening me. So anything happens to me, these people are liable for my life. Example. Okay. So injunction when it is refused. When the injection can be refused. See, I've given the certain points when the injection can be refused. Can anyone give the examples? One example for where the plaintiff approaches the court and the court rejects relief from higher court. Example. I need any example. No example. Means an illegal agreement cannot be enforced. Okay. Death. Yes. Death. Life threat to the family. Insufficient documents. So, see, example. Okay. Stopping the widening. See, if your plot is only 30-40 side, see, stopping from the widening, where if your plot is of only 30-40, in that only 5 feet is going away. So the compensation, the consideration is given by the government. Okay, if you feel insufficient, you can approach and then they may increase. Otherwise, it will be reduced. I mean, only that much compensation you will be liable to receive and you can't go further. Okay, government projects. Okay. If the court finds that appellant unsound, lunatic, okay, for the sake of public interest. Yes. So, injunction to perform a negative agreement. What do you mean by negative agreement? What do you mean by negative agreement? What do you mean by negative agreement? So, I will say that if ship comes within 24 hours from USA to India, I will provide $50,000. Okay. So can this be enforced? I'm doing a betting where I'm saying within 24 hours, is it possible ship to travel from USA to India? No. No. Yes, not possible. When you know that certain element cannot be made possible, so you can't accept. Partially impossible. Okay. So do not certain act and coupled with negative negative agreement do not certainly act. The circumstances are such that the court cannot grant specific performance, okay, specific performance relief, okay. It can grant an injunction, okay, or provide the time, okay. This is just an example, okay. So my main relief act covers is one when the contract is going to be breached, okay, where it's an immovable property or movable property, or if due to fraud or mutual mistake, some instruments have, like any contract had been entered, so there the court provides or specific relief to rectify the contract, then cancel the contract, I mean, come to hand, or cancellation of instruments. Okay. Then decisions or court orders. Okay. Then injunction where temporary relief. So 2 years. If anything happens to my property, these builders are responsible. There is no my free consent for the transfer of the title, perpetual. So any civil or emotional damages happened. to me. In that case, I can file and get the order from the court. Clear? This is all about the Specific Relief Act. So next, we are going to goods. Since we have, okay, so one question. My first question, since we have Contract Act and a Relief Act, so if you're, as per Relief Act, if you're not providing, like if the goods has not been so transferred, you have that you can compensate. Okay, if the goods are not like for movable goods, okay, if the compensation is not certain, okay, so you can take back the goods. Why the sale of goods act has come? To whom to protect? See, for any act to come in force, there would be a certain circumstances and situation to be happened. So Sale of Goods Act to easy of flow of goods. Yes, seller. Okay. Agreement to sell possible. Okay. Is whatever I transfer is goods. So whatever I transfer is a goods. So whatever I transfer is a goods. No. So I'm giving the money's worth of, I'm transferring, say, um, I'm transferring the amount of 5 lakhs to X person. Is 5 lakhs amount is a goods? Is 5 lakhs is a goods? No. Yes. So, in order to safeguard both buyer and a seller, the Sale of Goods Act has come into force, and it is regulated by law in India, Sale of Goods Act, and it has come into force in 1930. Okay, the provisions of the act is applicable only to movable properties. Okay, so I'm not speaking about immovable properties, and it extends all of India. Next, formation of contract for sale. Okay, so contract for sale, there is an agreement, first agreement, buyer and seller, transfer of property, immediate transfer or yet to be transferred, agreement to sell. Okay, so goods, existing goods, future goods, contingent goods. Okay, next, essentials of valid contract and prices, monetary consideration. This will be my contract of sale. So each one will be discussing now. So what is goods? Goods means, first I have told, it does not include any any immovable item. So goods is every kind of movable property. Movable property which includes tangible goods and intangible goods. Okay. Other than actionable claims. Actionable claims, money in circulation. That is money in circulation. Okay. And also includes stocks, growing crops, grass and things attached to or forming the part of land which agreed to be served. Okay. So like I'm providing the grass, like grass mat, like today in all the MNC field, they provide the grass or maintenance of grass. Okay. Even that will be a form of goods. Clear? On this example, also include stocks and shares. Stocks and shares such as preference shares, okay, or debentures. Examples. So they may ask the questions, okay, like MCQ. Since 40 marks MCQ you have, on this one question may come. I'm not saying definitely comes, may come on the Meaning of goods. Contract between buyer and seller. Okay, yeah. Goods means it's a movable item. Okay, whether it's intangible or intangible, other than actionable claims, that is your money. Okay, but includes your shares and stocks, growing crops, grass, and things attached to or forming the part of land which agreed to be served. Okay. Next, specific goods. So specific goods where there is an existing of goods at the time of contract. I'm not speaking about future goods. Speaking about specific goods when the goods were in existence during the at the time of contract of sale. Goods are owned, possessed, acquired by the seller at the time of contract. So there three are there. Specific goods contract were identified and agreed to sell. Okay, example, your phones or your washing machines, specific goods I have told. I told 10 kg, 10 kg what washing machine, but I received 7 kg one. But they have billed me for 10 kg weighing one washing machine. In that, that is specific goods. Ascertained goods. Okay, so goods which are identified in accordance with the agreement after the contract of sale is made. Okay, such as A owns 10 Maruti cars. B contract with A to buy one out of them. So from 10, any one I'm buying. Okay, that is ascertained. Unascertained means goods which are not specifically identified. Okay, at the time of making the contract. A owns 10 Maruti cars. B contracts to buy anyone out of them. Okay. Next, future goods. Future goods, the goods to be manufactured or produced or acquired. Okay. So by the seller after making the contract. Okay. That will be my future goods. Is future contract is void or valid? Question is, future contract is void or valid? Valid. On my future. See, my question is, the item, the goods is not in existence. Can I enter into contract? Not valid. It's unvoidable. I can have an agreement to sell. Yes, not valid. Okay. It's a future goods. Example had been for a farm, agricultural land, where a farmer had started to grow, say wheat. So I have given in advance of 5,000 example. So agreed that at the price of 35 rupees per kg, you sell me the wheat. Okay. So next, when the farmer gets the wheat produced, okay, after 3 months, so he'll be like that time they can enter into a contract and either at average price, if the price has gone to 36, so they can come into understanding and get at 35. Okay, it's an agreement, not a contract. Okay, contingent goods, the word contingent, can you tell me now contingent goods? What is the contingent? May or may not. So it is valid contract. No. Yes. So next, see on this MCQ question can be there. What is delivery? So delivery, my first condition is there should be a voluntary transfer. Voluntary transfer of position plus transfer from one person to another. Okay. Your option A will be voluntary transfer. Okay. Option B will be from one person to another person. Option C, is none of this. Now, which option you would select? Option D, A plus B. A, D, yes, D. See, if A plus B, if option D is not there, very close, voluntary transfer of the position. Okay, there is no transfer of item with pressure or fraud. Okay, so first thing, voluntary transfer plus transfer from one person to another person. It's called delivery. So delivery can be there in three ways. That is actual delivery. Actual delivery, I had a goods. Okay, so when you came to my shop, so you asked for 5 kgs of apple. So I had a good. I took the monetary consideration. I delivered you actually. Then constructive constructive delivery. Okay. Example, you ordered from Amazon. Okay. Say some electronic goods. Okay. At the time of delivery, you were not present. Your sister or wife or brother, someone were there in the house. Okay. I delivered the goods to your family member, but the OTP was received from your end. Okay. So in that case, if the delivery had happened, the goods has been transferred, okay, from the delivery person to the actual owner, okay, the buyer. That is called constructive. I had not transferred to you, but have given the goods position to your family member. Okay. Symbolic delivery. Symbolic delivery is where, so I had the 500 kgs of apple in one warehouse. Okay, in a deep freezer warehouse. Okay, now you had entered into a contract to purchase all 500 kgs of apple. In that case, so I've sold, I've received the consideration. So I will give the key of the warehouse. So that is a symbolic delivery, that I had transferred the goods to you instead of physical delivery. Okay. So these are the three types. Goods physically delivered, actual delivery, without any change in the custody or actual position of the things. Okay. So actual, the constructive. Next, delivery of the things in token of the transfer of something else. Key of the warehouse. Clear? Transfer of goods can be done when the transfer is effected without change in the position of custody. Yes, that is constructive. Example, I had ordered from the Amazon the item, electronic goods. Okay, but I was not in person. So my family member was there. On behalf of me, my family member had received the goods. Okay, so example here, a warehouse man holding the goods of A agrees to hold them on behalf of B. Okay, my family person has received and agreed to accept the goods on behalf of myself. Constructive. Physical transfer means I was not available in that time, right? Next, I'm saying agreement. Here, please have clarity between agreement and contract. In exam, confusion, they may give agreement. So don't take as contract. Okay. So I had 2 cars with me. So I wanted to sell to Mr. A. Mr. A. So he took one car and he was using. He paid a fair consideration as decided by third party valuer. Okay, that was 2019 model example. So when he got to know the same car in market, they are giving at higher price. Okay, so I've sold for 6 lakhs, but the car worth is 8 lakhs. In such case, can I avoid the agreement? Can I avoid the agreement? So now the person is asking, A is asking me that you give me another car also. Yes, agreement. It is not enforced by law. So when there is an agreement to sell the goods on the terms that the price is fixed by the valuation, so valuation of third party. So he biased, so he had fixed at 6 lakhs instead of 8 lakhs. My car was in good condition. Okay, such third party cannot or does not make such valuation. The agreement can be avoided. Okay, if the goods or any part thereof has been delivered, if one car has been delivered and appropriate by the buyer, he shall pay a reasonable price. Okay. So now on one car was delivered. Okay. Here the 6 lakhs he had told. So I can discuss with them. So I'll say in the market 8 lakhs is there. At least you pay me 7.5. Example. Compensation. The party is not in fault may maintain a suit for the damages against the party in default. Clear? So example is given to understand agreement to sell at valuation. Okay? Valuation. Next, nature of contract with in case of perishable goods. Okay? So example, there was A and B party. Okay, A is a producer, say producer of mangoes. Okay, now B had entered into contract that whatever yield you get in mangoes, okay, I will only purchase. Okay, whatever price is there. See, at the day of plucking the mangoes, B was not available. Okay, he kept in the storage for 2 days. He is not available. Now he is sold to C. Can he sell? My question is, there is a breach of contract. Okay, they had entered into a contract, not an agreement. Contract was there. Now it's an mango, perishable goods. Can he sell perishable goods? Yes. So can B sue, file a case against A? My next question, can B file a case against A? Breach of contract. It is not an agreement. B had told that whatever the mangoes produced in your farm, I will only purchase. You should not sell any of the mangoes to outsiders. Perishable can be avoided. No case can be filed. Yes, the concept is clear. Yes. So when B at the time of plucking, it was already the sweet mangoes. Okay. So at the time of plucking, B was not available. Either his agent was not available. He kept for 2 days. He saw no one was there. So he sold for C. Okay. Without the knowledge of the buyer also, he can sell. Where there is a contract for the sale of specified goods. Okay. No knowledge of seller at the time when the contract was made. See, at the time of contract, A was not aware that B will be available. Okay. Or the goods perished or became damaged. The contract is void. Okay. When there is an agreement to sell, okay, the specific goods without any fault, one on the part of the seller or buyer, before the risk passes to the buyer and subsequently the goods perishes or becomes damaged, the agreement can be avoided. Okay. So next, future goods. As I told, still the produce has not been there. Okay. So in that case, I can only come for an understanding, agreement to sell. Okay. And the contract is void from initio. So next, what do you mean by condition and warranty? Condition and warranty. What do you mean by condition and warranty? and given the notes. Warranty is for replacement. Yes. Pre-filled things. Yes. So there was an ad. So within 30 days, example, okay. So within 30 days, whatever the scar is, what appearing on the face, okay, will get cleared. An ad from the pharmacy, sorry, from some cosmetics, okay. My example is when what cream was available in the market, they had given the advertisement within 30 days, your scars on your face or any of your body part will be disappeared, cleared if you apply this cream. Okay. The condition is every day during the night. In the advertisement, it was told every day during the night you apply a layer of the cream so that the marks starts reducing. In this, the person, say Mr. A. So he followed all the condition except he didn't wash his face every day in the night before applying the cream. Okay. Then the scars has not reduced. Now can he file the case against the company? Why? No condition not followed. Yes. Yes. No. Yes. Next question is, I had brought like iron box, a new brand iron box. Okay, that had given me 5 years warranty. That whatever happens. Okay, so you get me, I'll get replaced or get repaired. Okay, so after 6 months, I started to see this what fire sparks. Okay, whenever I on, so inside the iron box, there would be a sparks or electric shock. So can I get replaced? Yes. 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 So bone meter case. Yes. Actually, one more is bone meter is filled with sugar only. And no person will become taller, stronger, and fit. Next. Yes, condition is certain stipulated conditions to be followed if you want to claim any damages. Whereas warranty means you have purchased the item. So any defects in your electronic goods, you can claim the damages. Okay, they can't refuse it. Okay, next, voluntary waiver. Voluntary waiver. Example. So I had given the furnitures to an charitable trust. Charitable trust. Okay, I saw their purpose. They were very good faith. Okay, they were like serving to the blind people. They want to create an employment opportunity to blind people. Okay, so I started to give a free of furnitures to them. So there, the consideration I'm giving waiving off. Can I do the waiving? Yes. Compulsory waiver. Compulsory waiver. Now, okay, like donation. Yes. Example for compulsory waiver you would have come across day to day. Waiver, waiving off, compulsory waiver. Any example? GST, yes. One time. Restoration.
Restoration, oh, yes. Amnestic scheme, yes. Compulsory waiver, yes. Yeah, these acts, contracts, it's not a contract where you're bound to complete, okay? You're bound, you're mandatory. Waiver, yes. Agriculture loan, yes. Natural calamity, yes. And COVID time for your EMIs or your any bounce, check bounce case were not valid. They should waiver of your interest. Yes, that is the examples for compulsory waiver. Either it can be expressed, conditions and warranties, either it can be expressed or implied. Okay, these are the examples and types. So, next, before whatever you can file the case against the seller. Now, one caveat emptor where it says seller beware, be aware, be aware. Okay, when you're purchasing the item, buyer is not sorry. Buyer be aware when you're purchasing the item. Okay, seller is not responsible. Okay, seller's duty to check. Example. Okay, one example. Please give me the example whether who is responsible. Okay, so I went for to purchase the horse. I went to purchase an horse. Okay, there was Ram. He was having horse. Okay, he showed me. Okay, okay, I took a ride also, but he didn't disclose the fact that horse is not fit for competitions. Competitions. It gives only for a ride. You can take a ride. Now, who is responsible? Either seller or buyer. Buyer had checked whether horse is fit, and he took a ride. It had a slow ride. Why seller? Buyer. Yes. Buyer's responsibility. I had purchased. I'm displaying the horses which I have. It's your responsibility to select the horse at your choice. If you want the data, I will give. But I never told that this horse is fit for competitions, horse race. As per his requirement, he is responsible. Yes. So in few cases, buyer is responsible. Okay, seller is not responsible. It is the duty of a buyer to examine the goods thoroughly. Okay, I had displayed whatever the horses which was in my shed before he buys. Okay, in order to satisfy himself. Okay, but the goods will be suitable for his purpose. He didn't mention me. The horse required for his horse race. Okay, which he is buying them. Okay, let the buyer beware. Okay, on these also the questions may arise. So conditions buyer had made to known to the seller. Buyer had made, if he had told that I need the horses which is fit for a race, horse race, then he would have shown the certain other horses. Okay, buyer relied on the seller's skills. Okay, sellers to supply goods of description. Okay, where this condition does not apply. So I wanted a water bottle which keeps my water warm for 8 hours. Okay, but the seller had given the other product. In that case, seller is responsible, not the buyer. Okay, I relied on the seller's skill. Okay, the exceptions, MCQ questions on these exceptions will be there. Fitness as to the quality, condition, goods purchased under patent or brand name. So if I'm purchasing the items under the brand, say as like Surf Excel, so that The brand as Surf Excel powder only shows that cleans the clothes very nice. Okay, that these are the exceptions. Okay, goods sold by description. Okay, and mercantile quality, and goods sold by sample. Sample buyer's responsibility whether to accept the sample item. It is his wish. Okay, goods by sample as well as description, trade usage, seller activities conceals the defects or it's guilty of fraud. Okay. So what do you mean by unpaid seller? Example. Unpaid seller example. See, there is description. What do you mean by unpaid seller? There is an example. But what do you mean? Any examples? Because we see or the effects is there on day-to-day business. Unpaid seller. Unpaid seller. $19. Credit terms, yes. Payment is pending for a long term, yes. But you need to pay either when you're purchasing next time. No, unless online purchase, unless you pay, the item will not be delivered. Okay. There is a control point. Dishonor of check. Okay. Sample sale. No, it is a free of cost. Sample is for just as making us advertisement. No, lack of supply, not. The person is ready to supply. Amazon is on what basis unpaid? No. Unbilled sales, wrong. Partially paid, yes. Credit sale, okay. So, see, unpaid, where the price is not paid or tendered and seller has an immediate right to action for the price. Okay. In your case of Amazon, if you have not paid at the time of ordering, but at the time of delivery, you need to pay. Otherwise, the goods won't be delivered. Okay. When the bill of exchange or other negotiable instruments has been received as a conditional payment, but it's been dishonored. When it has been dishonored also, he is known as unpaid seller. Okay. So first, rights of a seller. So he has, when the rights of, against the goods, against the good, right to lien, when the goods sold without any conditions. Okay. As per the specification, customization, when the goods has been sold, credit period has expired. Okay. Buyer becomes insolvent. Okay. In those cases, the seller can take back the goods. Okay. These three. Next, right to stoppage of goods. Okay. So this stoppage is the seller must be unpaid. First, parted with the possession of the goods. Goods in transit. Buyer has become insolvent. So, example, if you had ordered the goods in your Amazon, but at the time of delivery, if you are not paying the amount, okay, that time the Amazon has what ordered the delivery person, unless they pay, don't deliver the goods, don't give the possession of the goods. Okay. The right to stoppage. Okay. Right to resell. So right to resell. Okay. So Mr. B was not there. Okay. So he was not available for the 2 days. Okay. The goods are getting perished. Okay. In that case, he has a right to sell. Unpaid seller has given the notice of intention to sell. Clear? And if there is any personal damages, like, so I had given a credit of 10 lakhs. Okay, that was my working capital. Even though after 6 months, the person has not repaid back me. So I can suit for the interest. Okay, for any damages for non-acceptance. Then suit for a price. Okay, so I had sold the goods at the price of 10 lakhs, example, but you paid only 5 lakhs. Okay, still I have not realized, but the goods cost has been increased. Goods cost has been increased, and even after 6 months also you are not paying me the balance amount. So in that case, for the price also I can file a case. Next, auction. Auction. One example for auction. Example for auction. Tender, jewelry, house. Yes. When you don't pay your EMI, so you will have a notice, 3 to 4 notices. Okay. Even after notice, you're not responding and you're not denying from the payment. Default in payment, vehicle. Yes. Bidders. So in order to realize their loan amount, after all final notice for auction, the house can be auctioned. Okay. Recover the loan amount, balance they'll pay to the house owner. Who had taken the loan. Pawn broker can sell after the notice. Yes. Auction, bidding. Then who all get to know about the auction of the house? They can purchase. Who will bid the highest value? They can purchase the goods. Okay. Where goods are sold in lots. Okay. Completion of the contract of sale. Right to bid may be reserved. Okay. Where the sale is not notified by the seller. Reserved price, pretended bidding. Legal routes for auction sales. Clear? Clear? Still here? Gold loan. Yes. 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 So can we have today for 10 minutes break? So we'll be resuming at 7:30. 7:30. 7:30 class will be resuming. So, what is negotiable instruments? Is my money is negotiable instrument? Yes. Check. Yes. DD. Yes. Yes. Any other? Only check is negotiable instruments. Bill of exchange. Yes. DD. Okay. Mode of payment excluding cash. Yes. So transferable instrument, negotiable instrument in a piece of paper, creating the right to receive the money and corresponding liability to a person to pay. So, as per the Act, we have three instruments: promissory note, bill of exchange, and check. Okay. So, in that, first it should be in writing. Okay, first condition. So in an oral, I owe you the 10,000 rupees. So that is not an instrument. Okay, there should be a valid document, freely transferable. Means I can endorse the document. It should create a right of a person to receive a money and corresponding person, liability of a person to pay the money. Okay, holder's title is free from defect. Holder is due course acquires a good title irrespective of any defects in the previous holder. So so A sells goods to B. Okay. A sells the goods to B. So at the time when he received the goods, he didn't have money. So he promises to pay A after 3 months. Clear? He promises to pay after 3 months. Okay. In this, so A will say, I promise to you to pay for the goods worth rupees 10,000 after 3 months, and he will sign and he will give to A. Okay. In this, it's in writing, and there is no condition, uncondition. He is not saying, B is not saying that if you give 5% discount, I will be paying after 3 months. Example. Okay. Unconditioned promise and certain sum. Certain sum. Okay. This constitutes promissory note. Okay. So, promissory note is an instrument in writing, not being a bank note, that is your currency note, containing an unconditional undertaking, okay, signed by the maker to pay a certain sum of money. So in this example, B who promises, so he is an maker and he is an payee who accepts after 3 months, okay, who receives the money. So next, parties for promissory note, maker B, who makes the promissory note. He is a debtor from whom we receive, liable to receive, okay, payee, the person to whom the amount is payable, okay. So essential requirements of promissory note, it should be written, promise to pay, definite and unconditional promise. There is no conditions that after a certain event happening, I'll be paying. Okay, certain sum is there. To the maker and payee must be a certain person, signature and promise in money and stamped. Okay. Next is bill of exchange. So, same case, A sold the goods to B. Okay. So, now he don't have money. So, promissory note is not available. So, he draws a bill. So, here, so A, so he writes, I order to pay you or receive a certain sum of money. Sum of money. Here I'm ordering. Order. Okay. A will sign and B will sign and it should be stamped. Okay. And he is an maker. In this case, he is an drawer. Okay. And here he is an drawee who receives and who has a liability to pay. Okay. Whereas in first case, B is a maker who's promising that I will pay after 3 months. Okay. That is in promissory note. Whereas in bill of exchange, A is ordering to pay, okay, certain sum of money within a certain period. Okay. Clear? Yes. Clear. So if he's not paying, so he want to do immediate realization, he can transfer to C. That is called endorsement. Then he will be liable to receive. So, and an instrument in writing containing unconditional order. This is a difference between bill of exchange and promissory note. Promissory note is an unconditional promise. Here, I'm ordering a seller is drawing a bill of exchange on B. Okay, signed by the maker, directing a certain person to pay a certain sum of money to a certain person or to order of certain person or to the bearer of the instrument. If I have endorsed the instrument, he is liable to pay to that person. Okay. So drawer who makes, that is A. Drawee is B, who is liable to pay. Acceptor, the person who accepts the bill of exchange, normally drawee, that is B. And paying, when it has the instrument has been endorsed, means C, hence the A. Clear? So essential requirements, even this should be in writing. Unconditional order, then it must be signed. The instrument must be signed by both the parties. Okay. This there should be certain sum. A medium of payment should be money and money only. Okay. And it should be registered, stamped. Next, check. So check made over. Yes. So next is check. Check where an intermediary person is the bank, right? So I have the check where I have a check. I will pay to Mr. A, Mr. A or a bearer. So certain sum, I don't put 10,000 plus 10,000 plus 5% interest. As such, I don't write. So 10,000 only. And in this, and I will be signing. And here my SBI bank. Okay. So my question. So I am Mr. B. Mr. B had prepared the check in the name of A and given a certain sum of money. Okay. Now, who is a drawer? Drawer and drawee and paying. My first question, who is a drawer? Yes. Here, my intermediary party on demand. I'm not requesting. I'm not calling to my SBI bank. So, bank person, whether can I make can I draw a check today? No. There is an on demand, on order. I'm drawing a check. So, bank is liable to pay the money, certain sum. Okay. Drawer is my A. Drawee is my bank. That is my SBI. Pay is B, who receives the fund, who has the instrument. Okay. And even this is, whereas check is also known as bill of exchange, but is drawn on banker and payable on demand. Clear? Next, types of business. Clear with this? Yes. Okay. So do I need separate PAN to start my sole proprietor business? Separate PAN to start my sole proprietor business? Yes. Who is that person? Then an individual will have two PAN cards. I'm asking only for sole proprietor. Okay. So his individual PAN. Okay. So any other registration? Any other registration? Any other registration? GST. Okay. TAN. PT required. Udyam. Yes. So, yes, your statutory registrations, okay, MSME. If I'm starting an hotel business, what registration I required? Hotel business. SSSI. Yes. So this is very easy to start. So tomorrow I plan to start hotel business. So what on same I don't need to apply for a PAN. I already on the individual name I'll have a PAN. Bank account I will have. Okay. So on that basis required few statutory registrations and start my business. What about HUF? HUF, do they require the PAN? PAN requirement? Karta, yes. PAN, bank account, okay. To apply for the PAN, what is the major document? I can't apply on my own PAN, right? On individual. Yes. Trust deed. HUF deed. Not a trust deed. Yes. Affidavit. ID proof. Yes. Based on, so first you need to have a HUF deed in place, then representative person, and you can apply for a PAN and you can start a business and other registrations. Okay. Next, partnership firm. So there is A, B, and C. 3 partners. So how, what is the first thing they need to do? They want to start a business, say provision store. Provision store. Partnership deed. ROC doesn't come here. First is my partnership deed. Yes. Next, after partnership, PAN. Yes, PAN and TAN. Then firm registration. Yeah. With firm registrar, I need to get registered. I'll get the certificate. Then other statutory registration. Then I can open my current account. Okay. Okay. The next, my first one question. In the absence of partnership deed, in the absence of partnership deed, what is the ratio of sharing the profit between ABC? Equal. Equal. Yes. So what is the percentage? What is the interest percentage on capital? Absent of partnership deed. No. 12% when absent of partnership deed. Do I need to charge? No condition. So maximum, that's it. I'm asking interest on capital. There is no deed. When there is no agreement, the interest on partnership, sorry, interest on capital, what's the percentage? No, 0. Maximum you can charge if it's given in your deed. Next, LLP. My first LLP process formation. Same. It is same as partnership form, but it is registered under ROC, and at any point of time LLP can be converted into company. Okay. Now, my first step towards formation of LLP. Please, there is no deed. As per my understanding. Okay. LLP, ROC, name availability, run application. So you will provide two names, run application. Second, so one name has been allotted. So you need to fill the application, that is Philip form. Philip form within 20 days. Please, with not 60 days. One mistake which I made recently, where I thought I have the time period of 2 months. Okay, since the documents were not given by the partners, I delayed, so I was not able to apply for this name. So within 20 days, your LLP Philip form should be submitted. Okay. So one more option is there. If the time period is getting expired, you need to apply for extension of further 20 days. Okay. Even that has been expired. So one more option is, again, you need to file a run application. You have to attach your old old name, whatever the name approval which you got in previous approval, that name. So then you will get the same name. Okay. Next, for DSC and DIN, DSC and DIN of the partners. DSC if you are take. Next, you should have DSC to fill the Philip form. EMOA. It is not paper now. MOA and AOA. Agile form. Share ratio. Yes. Then you can apply in same form only for PF and ESI. After that, once you get certificate of incorporation, within 30 days, you need to upload your agreement, LLP agreement. See, partnership form you are getting registered, okay, with sub-register, but LLP agreement, so you are doing the run application, then you will get your certificate of incorporation, then the LLP agreement will be uploaded in the ROC portal. Don't forget this, okay? Else you will be receiving the notices, okay? Next, appointment of auditor. So we will just incorporate and live, but appointment of auditor, when we will do? When we will do appointment of auditor? 81, yes. Before completion, within 30 days, before completing my financial year. Okay. This is one privilege for LLP, not as company within 30 days. Clear? So, next, similar steps to one-person company also. Okay, you need to file a run application with the ROC, then fill the forms. But here, after getting incorporated, you have to file INC 20A, that is commencement of business. So, one-person company, private limited companies, okay, they should file within 120 days commencement of business. Okay. Else the further forms, you cannot file further forms. And every year the DIN should be activated, should be active. Else you need to pay 5,000 penalty and get activated. So if your DIN is not active, you cannot file the further any other forms. Yes, only one director. Yeah, in a board meeting, he himself can appoint. For one person, AGM is not necessary. The next. So as told, sole proprietor means the owner, where all the risks are borne by the sole proprietor. The sole proprietor has unconditional and full control over the business. There is no any other second party management. Okay. So examples, small examples. Advantage, quick decision. I don't need to arrange any board meetings. Okay. Immediate decision, confidentiality of the information of my business, direct incentives, sense of accomplishment, and easy of formation and closure. Whenever I can start my business, or if it's in loss cases, I don't want to go for closure legally. Limitations, management skills. Okay, one person, no person is perfect here. Okay, he may have certain limitations. Okay, example, if I have a sole proprietor business, okay, example, if I am very good at GST, okay, I'm not necessary to be good at income tax. Okay, I mean DT, right? There would be certain limitations. I know DT, but not good. Okay, example, limitation of resources. Okay, I can't hire experts. Example, unlimited liability, lack of continuity. Okay, formation, as everyone told, I need just Aadhaar and PAN, income tax, specific shop and establishment, state specific, law relating to professional tax, MSME, small scale industry or other related minor acts and GST registration. And even GST unless when your turnover exceeds. HUF with the deed, registered deed, obtain PAN, open the bank account and start the business. Partnership firm. It's a relation between persons agreed to share the profit of the business carried on by all, one of them acting for all. Next, features agreement between the two partners, and it should be in writing, and there should be an information where the business is started, so what is the object of the business, sharing of the profit and business motive, and who is responsible, who is an main partner who takes all the decisions, like whatever for the bank transactions. Okay, authorized partner. Advantage, easy of formation, and you get large resources and skilled people, flexible and sharing of risk, combination of different skills. Same, what are the deeds should contain address, name and address of the firm, partners, capital contribution, profit sharing, rate of interest, rights and duties, obligations of the partner, and settlement of the accounts on the dissolution of the firm, then on any retirement of the partner, retirement of any partner, what is the procedure, what would be the like how do we do settle their accounts, salary commission payable to partners, so there then rules to be followed, modes of settlement, any other affecting the rights of the partner. These are the three ingredients where to form for the partnership deed. So registration, so just get the name and apply in the application form 1 to the register, specimen of the affidavit, certified original copy you will get. Okay, partnership deed, proof of the place of business, then get other statutory registrations, LLP under ROC. Okay, so easy. LLP agreement. So here which all forms to be filled. So LLP agreement to be printed on 2000 rupees stamp paper. Okay. So first, run application, name reserving. Okay. Next, form of incorporation. Fill up form to be filed and submitted within 20 days after the name of approval. Form 3. So any information about LLP agreement or any changes. Okay. Within 30 days, the agreement should be uploaded. Then appointment of auditors. Okay. That is within 30 days from the end of financial year. Okay. If I started the business in the financial year 2023, so within 30 days. So within 30 days means before 31st March. Okay. Before 31st March of 24, I need to appoint my auditor. Then annual returns, form 11, annual returns. So annual returns where any change in partnership, okay, or any retirement or addition of the partner. So arrangements should be informed. So this, that is 30th, on or before of 30th May. This is the only one which is before September. Next. And statement of accounts. So once after you file your tax audit, if you are not under tax audit, July, your IT returns, okay. Then next you will be filing your annual returns with ROC. That is on or before 30th October. How many partners? Now for 5 years you can appoint as per company. For companies, how do you appoint? Similarly, for 5 years, you can appoint. As per LLP, who is the auditor? Whom you appoint, he is the auditor. Within 30 days from the end of financial year. There is maximum 20. No. Reappointment is not necessary. But as for companies, we do. So every 5 years we'll be renewing. So we'll be filing ADT 1, right? Every 5 years. Huh? So for that time you can appoint. Similar for company. Is there any qualification for? Sorry, any in LLP, any business you can do. 5 years. Turnover basis may start a tax audit. Statutory audit you need to do, right? Partnership in 20 in financial institution, 10 partners. Yeah, 20. So next, OPC company, 1 person, an individual person. Okay. So it will be distinct between an individual and the company. Okay. There, similar way, you need to apply for DSC, apply for DIN, name approval, and as for companies, how do you file the forms? Similar way, you need to file all these forms, and these all are e-forms. After that, declaration for commencement. Okay, for companies, 1 person and private limited, this is must. INC 28 within 180 days. Within 180 days of the date of incorporation. ADT 1 within 30 days from the date of incorporation, and KYC, and these all are similar. Clear? But days are slightly different. Okay. After your financial year and after your filing your IT return, you'll be filing your ROC filings. And private limited company means company having a minimum paid up share capital may be prescribed and by its articles restrict the right to transfer its shares and limits the number of members to 200 members in case of private limited company. And first run application, then file form, spice form, MOA, AOA, and PAN-TAN applications, including then documents, files to be uploaded, commencement of business, appointment of auditor, directors DIN activation, AOC 4 financial statements to be filed within 30 days of AGM. So the next MGT 7, your annual return affairs. Okay. And few are event based. One is when you're appointing your auditor, else ADT 3 when you're changing the auditor, removal, resignation of statutory auditor. Okay. All are within 30 days. Okay. Then next, DR 12 when change in director. Okay. Addition or removal of director. And example, you have taken a loan. So you have taken a loan from a bank. Okay. That is on capital asset. Capital asset loan of 20 CR. Working capital of 5 CR. Should I need to communicate to the bank ROC? Communication is required? Yes. No. Why? Yes. Okay. Why no? Person who had told. Yes, I'll clarify. Benefit is anytime one person you can convert into private limited company also. Okay. It will have a legal statute. Okay. Whereas one person, it will be a sole proprietorship. The name can be continued, except that one OPC will be removed when you convert into private limited. Yes. Charge creation is compulsory. Yes, charge creation is compulsory. When you take a loan, this will be actually few banks will be asking and will be following up regarding charge creation. Okay, else few companies had not done. On these also, when you upload your financial statements, you may get, there will be a chances of getting notice for not uploading your charge, because you would have mentioned as a bank loan in your financials. Okay. So company is required to file e-form, that is charge 1, within 30 days of creation or modification of charge. The e-form can be filed within maximum 120 days of creation or modification of charge by paying an additional fees. Okay. So even though from 20 CR, you had paid up to 5 CR, example. Okay. Even that after those modifications also should be communicated to the ROC. Next. So Section 8 company. So what is Section 8 company? So 1% company is started by individual. Yes, Section 8 companies, not profit organization. Okay. X GSTN. Okay. NPO. ICTPI. Yes. Yes. They are not for profit. They'll have the what as a company recognized, and any people come together. Okay, and they start the Section 8 company. Okay. So the name can include foundation, firm, association, federation, chambers. Okay. And next council, confederation. Okay. Electoral trust and other like etc. Okay. But the name does not include private limited company or limited company. So what is the main object? Is to ensure promoting commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment, or any other such object. Okay. Clear? Clear with this formation, types of business? Yeah, institute is not for profit. Education. Main purpose is to promote education. So next small topic is Shop and Establishment Act. So why this Shop and Establishment Act to be registered? Like why the companies should register under this act? Why? My question, why? Why to be registered? Answer. Why to be registered? Factory Act. No. Public Welfare and Employees Welfare. Okay. Labor Act. Rights. So here, Shop and Establishment Act, see, they ensure the social justice to the laborers employed both in the organization or unorganized sectors. Local authorities. So what would be the rights? So any benefits? So I guess you have heard, like, see, if, can you employ any minor person, children's? The Child Labor Act will be in force, right? So protecting a child, or or example, when you're not giving the maternity leaves, Women Welfare Act. Leave. Yes. Okay. These acts, if applied to people who are employed in shops, commercial establishments for public entertainment, amusements, and other establishments. What are the requirements? Okay. First is your ID proof of the owner. Okay. In the form A, incorporation certificate, authorization letters for authorized signatories, and you should pay a certain amount and file. So in that you will fill how many employees has been employed under you, what is the working hours per day, and where is the location. Okay, have you employed any other children or young person and women? Okay, what is your leave calculations? These rules on these things should be displayed. Okay, and annual in Karnataka there is an annual what annual returns to be filed. Okay, and few states there is no, it is not mandatory to file the shop and establishment, but you should take the registration. Okay, the rule is working per hour. So actual working is 8 hours per day. Example, but we are making the employees to work 16 hours. Even now, even I'm not paying the overtime amount also. So any one person can approach the register and file a case. Clear? And guidance for spread over rest intervals, opening and closing hours, close days, national and religious holidays, and overtime working. Okay, and employment of children's, young persons, and women. Annual leave, maternity leave, sickness, casual leaves, etc. And see, since one recent incident which I came across, there was a woman, okay, she was conceived, okay. In order to pay a paid leave, so the employer started to what pressurize indirectly so that she leave the company and go. Is it correct? No. Yes. So this act safeguards the person. So she can file that they're pressurizing unnecessarily from 8 hours, they're working for 15 hours. Huh? Okay. So employment and termination of services. So if the company terminates, they need to pay 1 month salary. Clear now? Maintenance of registers and records, display of notices, obligation of employees as well as employees. Clear? A small act. Yes. So can we take small MCQ? I'll just 1 second. Yes, this is my first question. First question answer. Morning in today's session. First question. What is general offer? $37, that's it. Option A, B, option A, B, D. A, B, A, B. Case law. Carbolic smoke ball. He had given a general offer, right? Or buy one, get one shampoo. Which will be for only specified period. Only for specified period. A, B, C, D, all. So, 1 second. Okay. Offer given to a specific person or persons and continues for a long time. Long time. So what is the period? Example, my what year-end sale. What would you call? Big billion day offer. 4 days. So even on 5th day, can I go and claim for an additional offer? No, right? Big billion day, Amazon and Flipkarts. No. Yes. An offer given to a specific person. Is my Amazon offer is my specific person? Anyone can order in my Amazon or Flipkart, right? So option A is valid? No. I'm speaking about general offer. Option A is not valid. An offer given to any number of people all over India, anyone can order the items until it is retracted, means taken back. After 4 days, order is not available. Okay. So I guess this option is okay. Next, an offer which is superseded by another offer. No. Counter offer I'm giving. No. An offer which can be accepted anytime and is never called off. Is my big billion day is not called off? Whole year the offer is available? No. So option is B. The first question option is B. Second question. Mr. Smart lends 5,000 to Miss Sweetie. Miss Smart tells Miss Sweetie after a week that she need not pay the amount. The contract is discharged by she doing any breach of contract, or there any additional contract, new contract has come. Yes, I'm waving off. I'm saying you are such a good person, you are doing a good activity. Furniture, example. I given the furniture to one charitable trust. Since their work was very good, were working for very good costs. So I told you don't pay anything to me. Waiving off. Option B, waiver. Question number 3. Yeah. A new contract is submitted in place of an existing contract. Is called what? Option A. Option D. See, I had taken a contract. So I wanted to add one more, an additional point. So I made a small alteration. No, but I'm saying new contract, totally a new contract. So I don't want product A. I need product B with certain specification. With parties are same. Okay. Consideration is also same. Okay. Same amount. Instead of Bosch company washing machine, I want LG washing machine. So I'm changing the contract. Recession, cancel. Option D, new contract in the place of existing. Option D. So next, question number 4. Yes. Question number 4. Under which of the following conditions can a proposal be revoked? I'm speaking revoked. Revoked according to the Indian Contract Act. Revoked means if seller before offer only, he takes back the offer. Before the buyer accepts the offer, he takes back the whatever the offer he had made. Example, I'm saying. Option A, by communication of notice of revocation by the proposer to the other party. Communication of notice of revocation. Option B, by the failure of acceptor to fulfill the conditions of proposal. Failure. By the death or insanity of proposer. By the lapse of the time prescribed lapse. By notice of revocation after acceptance is communication. So, after acceptance by the buyer, if he revoke, he cannot, right? In that case, option E, he cannot. So, answer is 1, 2, 3, 4. Which one? Option is not 4. C. A, B, C, D. He can revoke at any time by communicating notice of the proposer to other party. Okay. By the failure of acceptor. Acceptor didn't accept. Okay. His responsibility. He didn't accept. Okay. In that time he can revoke. Death of the seller. Lapse of time. Lapse of a time. Okay. By notice of revoke after acceptance. After the buyer has accepted the product, after that you cannot cancel. Clear? So option 3. Yeah, only ABCD. E is not there. I'm saying the technical words after, not before. So question number 5. Speaking about question number 5. So, how the preventive relief, that is specific relief act, is granted under specific relief act? Means before the builder does anything, threatens, I'm going for the court, at the discretion of court by perpetual, at the discretion of the court by injunction. So builders were threatening, I want to go out of country for 2 years. So anything, if my asset is getting sold, so anything, the title is getting transferred, I'm not responsible. Before that, I can get the injunction for temporary basis. Option C, both A and B. Option D, none of the above. Option B, again. So both are there. My option is C. When I can get the perpetual decision also, right? Option A from the court. Option B, for temporary base. Answer is option C. So my question number 6. When an injunction cannot be granted. When an injunction to restrain any person from instituting or prosecuting any proceedings in criminal matters. I cannot stop any person, right? So approaching to prevent the breach of contract, the performance of which would not be specifically enforced. Specifically enforced. Example, if you kill Mr. X, I will pay a certain sum. In that, can I file a case against Mr. A? Okay. There, even though there is a breach of contract, it's void at initial. Okay. To restrain any person from applying to any legislative body, I cannot stop any person, right? I'm saying cannot be granted. Or if court will say, okay, you go and kill Mr. A, I mean Mr. X, right? Option D, all the options. In any of these options, the court cannot grant the injunction. Question number 7. In which circumstance any person having the possession or control of the particular article of movable property of which he is not the owner, possession or the control of which is not the owner, may be compelled specifically to deliver it to the person entitled to and to its immediate possession. Means quasi contract. I got the stolen goods. So even though there is no contract, I'm liable to give the goods. I'm not the owner of the goods. When the goods would be extremely difficult to ascertain the actual damage caused by its. So position, immediate, having the control, okay, not the owner, to be compelled specifically to deliver the title, immediate position, movable goods, okay. When the things claimed is held by defendant as an agent or a trustee, okay, of the plaintiff, when the compensation in money would not afford the plaintiff adequate relief for the loss of the things claimed. So option D, yes, all of the above. So in these circumstances, the goods can be returned, should be returned back. Option D, yes. So question number 8. Question number 8. When the price is not determined by the parties to the contract of sale of goods, what price shall be paid by the buyer? When the price was not determined, what price the buyer will pay? Option D, the seller shall charge the price according to market force. The seller has not fixed the price. Example, Mr. Ram is my best friend. Okay, I gave him I gave him scooter freely, but he's not feeling to buy as such. So he'll inquire and he'll pay the reasonable price, right? The market price might be say of the scooter price is 1 lakh, but the scooter is already used. Option A, reasonable price. See, when I purchased the scooter, that time it was 60,000, 65,000. But today same scooter is 1 lakh. I can't pay 1 lakh. Depreciation is there. Okay. Option A. Question number 9. When buyer can sue the seller. Buyer. Buyer can sue. Question number 9. He may ask for specific performance. If this being the part of the contract, water bottle, example, condition, he may initiate for breach of warranty. So had purchased mixie for iron box, 5 years warranty. But when he's saying that even though warranty has not expired, he'll say I'll not replace. So that time buyer can sue. He may initiate sue for delivery of goods if not delivered. So you told that you'll be delivering the goods within 1 month. But even after 1 month, if you have not delivered the goods, after receipt of payment also, in that case also, he can file a suit. So option D. Yes, again, please read the question carefully, sir. In which case buyer can sue to the seller. Option D, all of the above. So next, buyer be aware. Question number 10. In a contract of sale of goods, the seller is under no duty to reveal unflattering truths about the goods. The doctrine is called as, why should I say the horse is not suitable for horse riding competition bidding, right? On horse you can travel. It's the buyer who want to check, right? Option B. Yes. Question number 11, last question. Which of the followings are not the negotiable instrument as defined by the statute? Are not. I'm saying not. B. Yeah. E. All the instruments are negotiable. No. Banker's notes. Banker is a medium who pay on demand in check. Option A. Banker's note. Clear? Any doubts? Any doubts? So, any doubts with today's topic? So, I'll be sharing